Hi team, and welcome to another video. This one is going to go over chapter 2 in the life insurance license course. So this one here, I'm so excited to go over. It's a short chapter, so I know the first one was a little bit long. We are going to be going over a shorter chapter today. It is called contract law. Okay, contract law. This is going to go over some terminology, right? More terminology that's going to help us on our exam understand the parties and all the pieces that are moving when it comes to insurance. Okay, so first things first, we're going to start with the terms to know. The first one that I want to talk about, and we're going to keep on talking about a lot of these terms. You're going to hear them multiple times. But if you hear them multiple times, this means that it's going to come up multiple times in your test as well. So the first one is consideration. Okay, consideration you're going to hear over and over again when it comes to insurance. So consideration is something of value that each party gives in order to make this contract binding. Okay, so something of value that each party gives to the other. This is the binding force in a contract. Okay, without consideration, there would be no contract. There'd be no reason for a contract because then it'd be a one-sided thing, right? Which is a unilateral contract. Okay, we're going to learn about different types of contracts as well. So a unilateral contract is a one-sided contract. Uni is one, lateral is way, right? A one-way contract. Unilateral contracts means that only one person or one party in this contract is legally bound to do anything. Okay, so like I said, unilateral, one-way contract, legally binding only for that one party. Next one is fraud. Okay, so fraud, you're going to hear about fraud quite a bit. And there's a difference between fraud and negligence. Okay, so fraud is intentional misrepresentations, right? Misrepresentations are basically lies. You're going to hear about those a lot. They're misstatements, they're not accurate, right? So intentional misrepresentations to deceit with intent to take something away, okay, to part with something. So any kind of lies, right, whether it be on the application for insurance and they're just trying to get past, whether it's submitting a faulty death claim, anything like that, it's intentional. These people knew what they were doing. Fraud is always intentional. That's the key word for fraud, intentional. Now, if it's unintentional, that's what they call negligence, okay? Meaning the person didn't really intend to do it. They just kind of didn't know any better, okay? So we'll go over that a little bit more. Next is insurance policy. We went over this last chapter, but remember that the insurance policy is what sets forth the contract of insurance. Okay, a policy is what sets forth the contract of insurance. Next is lapse, right? So we talked about premiums last chapter, what a premium is. Well, what happens when someone doesn't pay their premiums? Their policy lapses. Okay, so lapse is different than cancellation. Okay, when you cancel a policy, you're like, hi, Primerica, I would like to cancel my policy, right? You have to call in, you have to actually do that. When you lapse on a policy, it just means that too many payments have gone untaken or uncollected, and so the policy just closes out. Right? So lapse is policy termination due to non-payment. And then we have a misdemeanor. Everybody kind of knows what a misdemeanor and a felony is, right? A felony is like a big deal. A misdemeanor is kind of like a little bit less, but you still shouldn't have them, you know? So misdemeanors are a minor criminal offense, considered less serious than a felony. Okay, and we're going to hear about that when it comes to misrepresentation. Okay, so here we go. On to contract law and tort law. So contracts are written agreements that are legally enforceable by law, right? Legally, it holds each side to this party accountable. And that's important for the contract because, like I said in the last chapter, with utmost good faith, the policy owner needs to know that the insurance company is going to pay out, or else there's no point in a contract. And the insurance company needs to know that this person is going to pay their premiums and that they are going to be honest and upfront on their application, or else there's no trust there, right? So contracts are written agreements that are legally enforceable by law, okay? Consideration. Okay, what is consideration between the insurance company and the policy owner? Here is the consideration on both sides, okay? So in the insurance policy, consideration on the party of the policy owner, the person who's going to be paying the premiums, the person who applied for this, they have two things that the insurance company needs. They need the promise to pay their premiums and abide by the laws or provisions set in this contract. And two, their honest and upfront answers on the application. That is the something of value that the policy owner is giving in this contract, right? Now, the consideration on the insurance company's part, right? What are they giving in this contract? It's the promise to pay in the event of the loss, right? So if one of these two parties is not going to hold up their end of the contract, that's not good for either party, right? So consideration is the binding force in any insurance contract. All right. So what is a tort? You probably won't hear about this on your test, but just in case you do, here's the definition of a tort. Okay, so a tort is a private, civil, non-contractual wrong that happens for which a remedy through legal action may be sought. Basically, right, if someone is doing something wrong on one of those two parties, these parties can seek legal counsel against the other, right? A tort is basically like a misgiving, right? It's an incident. It's a negative incident. So whether it's the policy owner not being honest, right, or not being honest, like on their application, if it's that big of a deal, the insurance company could take action. Let's just say the insurance company doesn't hold up their end of the bargain, right? Or maybe someone's denied when they shouldn't have been, like just something like that. That is considered a tort. This means it's an issue that could be taken with civil action, meaning like you could take them to court. You could sue if you wanted to. Okay. Perfect. All right. So the elements of a contract. This is important. We're going to be tested on all of these 4 elements to a contract. So a contract, like I said, is defined, right, as an agreement between 2 or more parties enforceable by law. Once you're into that contract, it's enforceable by law. It holds you accountable. In order for this contract to be legally binding or enforceable by law, it has to have certain essential elements, okay? Certain things have to be there. The first one is going to be agreement. So we're going to jump right into it. There must be a definite offer by one party, and the other party must accept this offer in its exact terms. And I'll explain that right now, okay? In insurance, the applicant usually makes the offer, even though we think, oh no, the insurance company is offering me the insurance. That's not true. What we are seeing happen here is that the proposed insured, right? The applicant, the proposed insured, those two things mean the same, right? They are proposing, they're asking the insurance company, hey, based off of my age, medical history, occupation, and sex, right? Can I be approved? That is actually the offer. Okay, that is the offer. And the insurance company either accepts this person or denies them. Like I said before, the insurance company it's not mandatory for them to accept us. So they have the option whether to accept or deny this person, right? So, agreement, right? Number one, agreement. There must be a definite offer by one party and an acceptance or agreement by the other party. Agreement or denial, you know. Okay, so number two, consideration. You're going to hear this word over and over and over again. Consideration is the binding force in any insurance contract. It is something of value that each party gives in order to make this contract binding, right? The something of value on the insurance company's part is the promise to pay if a loss occurs. For the policy owner, the something of value is their honest and upfront answers on their application and the promise to pay their premiums and follow the provisions. Okay, so consideration has to be there. Without it, there's no contract. Number three, competent parties. Competent parties, and there will be most likely a trick question on your test about this section as well. So competent parties, this is why this is important and what it means. So the parties of this contract must be capable of going into the contract and understanding it in the eyes of the law, okay? And that's the key there, in the eyes of the law. Generally, this requires that both parties, right, the agent and the applicant, right, that both parties are of legal age, right? They are mentally competent, meaning like people maybe with dementia, probably not considered mentally competent, you know? There's a lot of other issues that could go along there, so I'll just leave that there. They have to be mentally competent to understand the contract and then not under the influence of drugs or alcohol at the time of the sale. Okay, example. Technically, we are not supposed to be selling insurance under the influence. If you happen to, let's just say you're at a family barbecue and you sit at the table and you have your cousin across from you and they're like, you know what, I haven't seen you in forever. Let's just get that quote going, right? And they crack open a cold one and they start drinking. Technically, we're not supposed to follow through with that quote. We're not supposed to make the sale with them impaired. Okay, so mentally competent means of legal age. It means mentally competent, right? We have to be able to understand the contract and not under the influence of drugs or alcohol. Now, these are the trick questions or trick answers that'll be on the question in your test. It'll say, person with a felony or people with background issues. People with background issues are not mentally competent. They have background issues, so maybe they make poor decisions, but they're not mentally incompetent. Okay, so that is incorrect, right? I think that's the one that you see the most. I can't really think of another one, but felons are not mentally incompetent. So when you see that on your test, it'll say which of the following is not, right, an example of, or is not an example of an incompetent party. And it'll say all of the following, then it'll say felon, right? People with background, issues, they are perfectly competent. That's not correct, okay? So keep that in mind. And then 4, there has to be a legal purpose for this. Like I said in the last chapter, there needs to be insurable interest, right? Insurable interest means there needs to be a reason why this policy owner is pulling out a policy on this insured person, right? So the purpose of this contract must be legal and not against public policy. I will say this again because you will probably see it on your test, guys. So legal purpose, it must be a legal policy and not against public policy. That's all I don't know how to explain that. I don't have a good description for it. All I know is that statement right there. Just get familiar with it because I've seen it twice on my own exams, okay? So to ensure legal purpose of a life insurance policy, for example, it must have both insurable interest and consent, meaning the insured person has to know that a policy is being pulled out on them as well. Okay, so there has to be consent and there has to be insurable interest. All right, next one. Okay, so they say that these are special characteristics, but I want you to think of them as terms to know, okay? So the first one is contract of adhesion. Okay, these are terms that we need to know. We just need to know what these words mean. They're not going to use them in any kind of, like, what's an example of? No, they just need to know that you know what this word means. So contract of adhesion, this means that a contract is prepared by one party and is accepted or rejected by the other party. Okay, so it's prepared by one party, and this is the insurance company, and it's accepted or rejected by the other party. And I know you guys must be thinking, but Carly, in the last slide, you said that it's the other way around, that insurance is offered by the policy owner and accepted or rejected by the insurance company. Yes, that's true. But once they send you this policy, right, you have a certain amount of time to accept it or reject it, right? If you see something in the fine print that you don't like, you can send it back. You can reject this policy. So contract of adhesion, right? It's prepared by one party and it's accepted or rejected by the other, okay? Insurance companies or insurance policies are not drawn up with negotiations. Like you can't be like, oh, actually, really quick, 3rd paragraph down, I don't like this section. Can you take that out? No, that's the terms of the contract, right? So they are not drawn up through negotiations, and the insured, meaning the person being insured, has little to say about the provisions inside this policy. In other words, insurance contracts are an offer on a take it or leave it basis by the insurance company. Okay, any ambiguities, right, which just means questions or gray areas, right? Any gray area, that's the one we're going to use. In the contract, right, it doesn't specify which way or the other, will be favored in the insured's favor, basically. Right? So for a contract of adhesion, we just need to know that it's accepted or rejected by one party and prepared by another, that this is offered on a take it or leave it basis. Okay, take it or leave it basis. That's what contract of adhesion is known for. Next is called a conditional contract. What is a conditional contract? As the name implies, a conditional contract requires that certain conditions are met in order for the policy or met by the policy owner and the company in order for the contract to be executed, right? Before either party fulfills their obligations. For example, in order for this contract to be valid, right, and be enforced, the insured, the policy owner, they have to pay their premiums. right? If they stop paying their premiums, then it lapses. And they need to submit a death certificate, or else the insurance company cannot pay out, right? So certain things need to be met in order for this contract to get paid out. There are conditions that need to be met in order for the payout to happen. Next word is aleatory, right? Aleatory. So insurance contracts are aleatory in nature, which means that there is an exchange of unequal amounts or values, right? Think about it. We only pay $50 a month for this policy. They promised to pay us $300,000 in insurance coverage, right? Insurance benefit. That's kind of aleatory, right? We have this little baby amount here and we have this big, huge payout here. That's what that means. So aleatory just means that there's an exchange of unequal amounts or values. Okay. Next one is unilateral. We already went over unilateral for the most part. A unilateral contract, only in a unilateral contract, only one party is legally bound to do anything. Okay. The insured person, here's the example, right? We have the insured person and we have the insurance company. The insured person, right? Let's just say it's me and I'm paying my premiums. Am I legally bound to pay those premiums? Are they going to come and knock on my door and take me off to jail if I don't pay my premium? No. Are they going to sue me if I don't pay my premiums? Also, no. They're just going to term out my policy. They're going to lapse it, right? But if an insurance company does not pay out when they should, they are legally bound to pay out. So what's going to happen? There's going to be consequences. So see how that's a unilateral contract? The policy owner or the insured person, whoever's making those premiums, is not legally bound to pay them, right? They should, but they're not legally bound. But the insurance company is legally bound to pay out if a loss occurs. Okay. All right. So now we're going to be going over those legal terms that I talked to you guys about. We've already said this over and over, but an insurance contract, right? I'll just say it one more time so hopefully it sets in. The insurance policy itself sets forth the insurance contract. Okay, so the insurance policy is a written instrument in which a contract of insurance is set forth. It's started. Okay. Next, we have what are representations. So representations are basically statements, right? They're statements that people say, but they're not really facts, right? They could be true, but they also could not be true, right? So representations are statements believed to be true to the best of this person's knowledge, okay, at the time. But they're not guaranteed to be true. They're not facts. They're just statements. Everything I say is considered a representation, right? Like, oh, I'm 32, right? That's a representation. You don't know if I'm 34 or 36 or 31, right? Like you don't know. It could be true, and we're going to take that as it is. We're going to believe it to the best of their ability. Okay, that's a representation. Now, untrue statements, right? Untrue statements are misrepresentations, right? False statements, really, right? And these could void the contract, okay? Then we can take it a step further. A material misrepresentation. And when you see material, I want you to think of like heavy. Like how much does this matter? Is it a big lie? Is it like a super heavy lie? Or is it like a little baby, we can fix this lie? Right? So a material misrepresentation is a statement that, if discovered, would alter the underwriting decision, right? Like, let's just say I did the application and I know very well that I have cancer, but I say, nope, I don't have cancer. And they approve me, but they find out later that I have cancer and that I knew I had cancer at the time of application. That's a material misrepresentation, because if they would have known at the time of underwriting, they would have declined me or denied me, right? So material misrepresentations can happen, right? Sometimes people forget, or they just don't know, or they misstate, right? Like they just say no, but they're like, oh man, I totally forgot that I was actually just diagnosed with cancer. That doesn't really happen, but you know what I mean? Like it could just be an accident or a mistake. But if a material misrepresentation is found out to be intentional, right? Like I knew exactly what I was doing and I really needed the insurance, so I lied. That is considered fraud. Okay. Like I said, anything that's intentional points straight to fraud. Anytime you see that word, intentional, fraud. Like it was done on purpose. Okay. All right. So representations, right? Statements can be changed or withdrawn from the contract prior to the beginning of the policy. So prior to the policy being printed and mailed out, these statements can be changed or withdrawn. Okay. But there's a special way that we need to do it. We can't just be like, oh, we can't just have someone like scratch it out and like write something else in. No, there's like an official way that we need to do it, and they'll ask you that on your test. So the way that we can withdraw this information or change the information is going to be to start a whole new application, right, from scratch, like with no errors on it, or it can be crossed out one time with the initial of the insured person next to it, stating that there's been a change and I approved of this change. We cannot, under any circumstances, white out any answers. We cannot, under any circumstances, erase answers. It's either start a whole new application or have the person initial the change. Those are your only two options. Anything else, if they give you that example on your test, it's a no. Okay? All right. Perfect. And then a warranty. So this would be the last one that goes in that little group. A warranty is basically a statement that's guaranteed to be true. Okay. A warranty is a statement considered to be guaranteed to be true and becomes part of the contract. And the definition or the example that I want to give you is medical history, right? When we go through and we're asking people about their medical history and they tell you, hey, I've had Hodgkin's lymphoma, right? They're not just making this up. They're not saying like, oh, I think I have Hodgkin's lymphoma. Like, no, that's something that they've been diagnosed with and that there is most likely medical history to back that up, right? So we can take that statement as a warranty. Unless someone's like a pathological liar and they just said it to say it, I highly doubt that would be the case, because giving that kind of information can get them denied. But instead, they were upfront about it and they were honest about their medical history. So something like that can be taken as a warranty. We can take it to the bank. It is almost guaranteed to be true, right? So that's what a warranty is. Next, we have materiality. Materiality. Okay, materiality. Okay, so like I said, every time you see the word material, I want you to think of matters. Like, how much does it matter? How heavy is it? Okay. The concept of materiality is based on the idea that all parties to this contract are entitled to the information necessary to make a solid decision. Okay. So materiality is basically determined by the probability of this statement being a big deal, like mattering. Okay. That's why it's kind of hard to explain it. It's just, it matters. How much does it matter? Does it matter a little bit or does it matter like a lot? Right? So materiality means how big of a deal is this statement? Okay. Next, we have concealment. So I talked a little bit about concealment at the end of the last chapter. Concealment means you are basically, in legal terms, right, you are intentionally withholding information. Okay. You know information and you're not being upfront with it, basically. And it's not just regular information. Concealment is it's not that you unintentionally left it out, right? It's not something you forgot. You knew and you intentionally did not give that to the agent when you were doing your application, right? So concealment is a legal term for the intentional withholding of information of material fact. Okay, like I said, big deal, right? Material fact. It's something that needed to be known and you did not let them know. Okay. And it's crucial in making a decision. In insurance, concealment is withholding of information by the applicant that'll result in an imprecise underwriting decision. Okay. And then concealment may void this policy. And a lot of times it's fraud, right? If it was intentional, with which concealment is intentional, it's fraud. Okay. Perfect. And then the last one is fraud. Like I said, we already talked about it a couple times. So fraud is the intentional misrepresentation or misstatements or intentional concealment of material fact, like it was something big. Used, and this is the part, used to induce another party to make or refrain from making a contract or deceiving or cheating a party out of something. Okay. Fraud is grounds for voiding this insurance contract. And if it's a big enough deal, they can also press charges, which is where the misdemeanor comes in. Okay. Now, what happens when they need to take your contract away? Right? It's not like you didn't pay your premiums. It's that you lied. So what are they going to do? They're going to do something called rescission. They are going to rescind the policy. So rescind is RESCIND, right? That's like taking it away. When you see rescind, I want you to think of like snatching a bag. Okay. So rescission of the policy means to take it away. And you can see rescind, rescinding, rescission, all of those mean the same. It's the same word, just in different context. Okay. So rescission is the revocation of a contract. It's basically saying like you had it, now you don't. We're taking it away. To rescind something is to snatch it away, to take it away. An injured party is entitled to rescinding the contract if any of the following occurs. So 1, a false material representation was given, right? A statement that was untrue, concealment was found, or a violation of material warranty or any other provision in a policy. They may ask you, who can rescind this policy? The insurance company can, but the policy owner can also rescind the policy. How? I don't know. I really don't know. Maybe complain to the company and then get it voided out. I don't know. But there would be some kind of misrepresentation on one of the sides of the party. I just know that on your test, it may ask, who are the parties that are able to rescind a contract? And it's both. Both parties can rescind, but normally it's the insurance company that's going to be taking that contract away. Okay. Alrighty. And then lastly, we're going to cover just a few important terms. Ones that I've already gone over, I'm going to skip through, but ones that we need to know for the following chapters are going to be here. So we already know what a policy is. We already know what an application is. Now, a rider. Okay, you're going to be hearing about this later on in the chapters, but I just want to give you the gist of what it means. So, a rider is an addition to the policy. Okay, it's an add, right? To modify it, to modify those provisions. Think of a wagon as the insurance policy. Riders jump on and they stay on, right, till the wheels fall off. They just stay there. It usually gives you better benefits or some kind of addition that you wouldn't normally get with a regular insurance policy, with your standard insurance policy. Okay, so we'll go over that more. I already went through cancellation and lapse. Renewal. Renewal is going to be when someone comes to the end of their term, right, of their insurance contract. Let's just say it's term insurance because that makes the most sense. They can then renew. Okay, so we'll go over that more. A grace period. A grace period is the period of time after the deadline or due date of a premium that the insurance company basically gives you to send in that late premium. Normally it's 3 months. Okay, so a grace period can be different depending on the company, depending on the state, but the grace period is normally 3 months that they give you before they lapse your contract. Like they're going to keep on trying to reach out to you. They're going to try to do everything in their power to get you to get that insurance policy to current. Okay. All right. And we already talked about rates. And we already talked about units of measure in the last chapter. So if you guys do need a little refresher on the first chapter, feel free to go back. We talk about units of measure towards the middle and end of that chapter. But other than that, guys, I know that was a lot of terms to take in. Like I said, we want to be quizzing and quizzing and quizzing and constantly hearing these new terms. That way we can kind of take in this new information and this new language that we're going to be learning when we're preparing for our insurance license. I hope you guys are having a great night and have a good one.